Everybody, it looks like we've got critical mass for folks attending. My name's Kendra Leichhardt. I'm an officer with the Real Property Section for the LA County Bar. And this event is being provided by the Litigation and Real Property Sections. I'm going to turn it over to our moderator, Peter Balance.
Great, thanks, Kendra. Good afternoon, everyone. Thank you for joining us for today's CLE Brown Bag discussion hosted by the Los Angeles County Bar Association. I'm Peter Balance, a partner at Shepherd Mullen in the Real Estate, Energy, Land Use, and Environmental Practice Group, and I'll be moderating today's panel on legal issues arising from the recent fires in Los Angeles. First, let me tell you a little bit about myself. My practice focuses on commercial real estate transactions with a particular emphasis on real estate finance. I represent institutional lenders, borrowers, developers, and property owners across the country in a wide range of transactions, including loan restructurings, workouts, foreclosures, and distressed real estate matters. I have extensive experience advising on non-performing loans and the challenges that arise in the wake of economic downturns or major disruptions, such as the fires that have devastated parts of LA. Our discussion today will explore critical legal issues arising from these recent fires. We'll cover key topics, including insurance coverage disputes, business interruptions claims, regulatory relief such as FEMA assistance and mortgage forbearance, and the impact of fire-related damage on commercial leases. Our panelists bring deep experience in these areas, and I'm excited to introduce them now. Our first panelist is Ted Sennett, a partner at Gibbs Giddon. Ted has extensive experience in environmental, construction, insurance, and real property law. He's been involved in major infrastructure and commercial projects and has handled insurance claims related to wildfires, storms, and other disasters. He's also a LEED accredited professional and has taught insurance and construction law at Loyola Law School. Welcome, Ted. Could you start by sharing a little more about your background?
Thank you, Peter. The most analogous experience I've had to the fires, I think, is the 1994 Northridge earthquake. It involved multi-billions of dollars of losses and urban disaster. From that experience, I obtained I had my first insurance appraisals, which is a dispute resolution process in many insurance policies. But I also found that there was just a myriad of disputes and types of litigation that came out of that event. And I think the same situation will happen here. We'll see a lot of losses, claims, and litigation that'll be first. There'll be laws made and new technologies developed. In about 2009, I became a lead AP, which introduced me to the concept of building resilience. And since that time, I've spoken at ABA conferences, industry groups, public agencies, and at law schools regarding loss mitigation and loss management. And as a result of that, I've spoken on everything from fires, floods, environmental disasters, pandemic, and building defects. So that's somewhat my experience. I think that is, I built on that, and of course have dealt with a number of fire and flood losses since that experience. But that's really informs me of what I think is ahead down the road.
Great, thanks, Ted. Our second panelist is Lissa Roberts, an attorney at Panish Shea Ravipudi, LLP. Lissa is a trial lawyer specializing in catastrophic personal injury, wrongful death, and property liability cases. She has secured hundreds of millions in settlements and has played a key role in wildfire litigation, serving as liaison counsel for the Southern California fire cases. Over the last decade, she's represented thousands of victims of utility-caused wildfires, including the North Bay and Camp fires, the Thomas and Woolsey fires, and the current Maui fires in Hawaii and the Eaton fire in Altadena. She is an essential voice in today's discussion. Lissa, could you tell us a bit more about your background?
Hi there, Peter. Hi, Ted. Thanks so much. Yeah, I started out, I've done plaintiff's work since I graduated law school in 2004. And have always enjoyed representing people who have had, a horrible thing happen to them and hopefully getting them in a position to recover from the loss, the damage, the injury, whatever it might be. And these fires have affected huge numbers of people in our communities across our state, also in other states such as Hawaii, Oregon, West Coast, Western United States. And it seems as though we're dealing with something that's going to be with us, unfortunately, for many years to come with these wildfires. And so about 6 or 7 years ago, I got involved with representing folks who had been suffered some sort of a loss in the PG&E caused fires up in Northern California, and I worked on those for a number of years, as well as on the Thomas fire. I've represented people and worked up damages in civil litigation for uninsured losses and underinsured losses, for hundreds and hundreds of people. Obviously, it runs the gamut from the total loss of a residence, displacement of families, uprooting of entire communities, through the loss of loved ones, which, we've had some really horrific tragedies that stem from these fires, including the Montecito mudslides back in early 2019, followed the Thomas fire. I represented nearly all of the families of the decedents from that tragedy. And then we've got, the Eaton fire, we've got Camp, one of the biggest losses of life as a result of wildfire. So these are things that, these are important issues that affect our communities and will continue to. But I've really, I thought I might be doing something different now that Woolsey and Thomas were wrapping up. And unfortunately, I don't mean to make light of it, but the Eaton fire and the Palisades fire and the Hearst fire, we're just, it's continuing because these are believed, at least the Hearst and the Eaton fire, are believed to be utility caused as well. So the fight continues on.
All right, thank you, Lissa. Okay, now that we've introduced the panelists, let's dive into today's discussion. Wildfires continue to be a major issue in Los Angeles and across California, raising legal challenges across multiple areas. Today, we'll focus on 3 key areas. The first is litigation claims and disputes. The second is the first is insurance claims and disputes. The second is litigation and liability. And the third is regulatory and financial relief. We'll cover each of these in turn, and I'll direct some questions to our panelists. And we'll also try to leave a bit of time at the end for audience questions. So first, insurance claims and coverage. Lissa, let's start with you. Can you walk us through the key considerations for policyholders when reporting a fire-related loss?
Yes. If you give me 1 second, I will try to make this okay. So insurance claims and disputes. So key considerations for policyholders. Some of these may seem basic, but I think it's worth going through them quickly. Home and business owners seek protection against calamity and purchase insurance to buy peace of mind and security. So the basic rules of the road is that the insurer has a duty to give as much consideration to the interests of its insureds as it does to its own interests. The insurer must promptly, after a claim is filed, conduct a fair, balanced, and thorough investigation with a view towards paying the claim. And an insurer must not focus solely on those facts that would justify a denial, but instead need to look at the evidence with objectivity and, with an eye towards paying the claim. Some issues that arise with claims handling from the perspective of an insured: you really need to get an accurate scope of loss if you're either a victim yourself or if you're representing a victim, or taking a look at insurance issues. The scope of loss is important because it defines what needs to happen to right the wrong, right? It's an itemization of everything that needs to be done to repair, replace, or restore the property to its pre-fire condition. And it will include everything from, structure, foundation, erosion issues that tend to arise after a wildfire, vegetation, loss of landscaping and hardscaping, and any other issues. It also would include code upgrades. Many homes that are destroyed in our communities are 20, 30, 40, 50 years old and older, and may have not been built with certain code upgrades. That's important to be looking into. Especially, as I think Ted might have alluded to earlier, when you have upgrades and technology and things like that that may help to rebuild a home that's more fire resistant. It's just different from an estimate, which is an itemization of what it's going to cost to do that work. Homeowners should get their own scope of loss. If you've done any work adjusting claims or adjusted your own claim with your insurance company, they have their own system of doing scopes of loss. It's really important to get one that's independent in order to value the extent of the claim, and to also be thinking about whether a homeowner is underinsured if they have insurance at all. If you don't have an independent scope of loss, you may have a client, or you may be a person who either doesn't get completely paid out on your policy limits, or it just may not identify everything that needs to be done to identify that you're underinsured, and then to take action after your insurance claim is adjusted. A couple of statutory things to be aware of in the state of an emergency. Additional living expenses. In the event of a total loss, the insurer shall advance at least 4 months of what is known as ALE, additional living expenses. This is a category of coverage under most policies upon request, and that's under Insurance Code 2061. Another statutory requirement to be aware of in the state of emergency under personal property coverage, if there's a total loss and the dwelling was furnished at the time of that loss, the insurer shall offer a payment of 30% of the policy limit to the covered dwelling up to $250,000 without having to itemize everything that was in the home. I can tell you, representing a lot of folks who've lost their home, this is a very difficult thing for them to do, to itemize everything that was in their home that was lost, either because of the traumatic experience, because they're not sure, because they're overwhelmed. So this is something that can help to get them rolling, getting the proceeds of their insurance policy without having to do an itemized list. And then as to dwelling in the event of a covered loss, not necessarily a total loss, there's a distinction there. The insured shall be permitted to combine their primary dwelling and other structure limits towards rebuilding or replacement of the primary dwelling if those limits are insufficient to rebuild or replace. That's under Code Section 10103. And just as another note, if a homeowner wants to relocate and not rebuild their home, and insured under the law in California, an insured homeowner can recover full replacement cost in order to purchase a replacement dwelling. Getting through the adjustment period. This is actually something, and Ted, I will pass to you in a second here, but in terms of time limitations that insureds need to be aware of, or you as their lawyer need to be aware of, is equitable tolling. Did I pass something? Here it is. I'm sorry. You need to be aware of the contractual limitations period. Almost all of these homeowners policies include a suit against us provision, which imposes a limitation of 1 year from the date of the loss in order to bring a claim against the company. The date of loss is the point in time at which the damage occurs or should be known to the insured, such that an insured would be aware that his or her notification duty has been triggered under the policy. And equitable tolling does apply here, however. The clock stops upon notice to the insurer, basically during the period of adjustment. So while the insurance company is reviewing, investigating the claim, that clock is stopped, and then it starts again upon written denial of the insurance company or notification that the adjustment of the claim is complete. I don't know that I kind of went into the timing. I don't know, Ted, if you want to comment on that at all, the timing issue, or do you just want me to continue through?
Oh, well, why don't you continue, and I'll come back to it.
Got it. Okay. Just a couple of other points. Anyone working on any of these cases, you've got to read the policy, and you got to understand the types of coverage and amounts that are available to somebody who is going through this process. Other tips and things to be considering is that you're getting everything in writing from the insurance company, that photographs and video, that the damage is essentially documented, right? I'll just give one quick example. In Eaton, it was heavily vegetated before. Oftentimes we can go back and look at Google Earth imagery to see what was there before. But when there's heavy vegetation covering residential areas, that can be difficult. So the debris before it is removed is actually quite helpful in terms of estimating repairs and replacement. So having it well documented is important. People want to get their debris cleared quickly. That's something that a lot of folks are trying to do right now in the Eaton fire situation, but having it fully documented is critical. Important to get insurance approval before beginning those repairs. And this is important. There is no requirement that an insured has to sign a release in order to be entitled to start receiving their benefits under the policy. In fact, we advise folks that if your insurance company is asking for you to sign something in order to get benefits, you may want to consider that as a red flag because it's not required. You want to know what you're giving up before you do that. I think that was that section that I ran through quickly. And so we can come back to this later. I will stop sharing and pass back to you, Peter.
Yeah, so Ted, I know that you may have had some additional information on deadlines and pitfalls that policyholders should be aware of.
Yeah, so I've got a slide here that covers the basic duties of the insured. I'm going to give some tips to practitioners on these topics. The first one Alyssa touched on, and that's get a copy of the policy. I'd go one step further and say get a copy of all the potentially relevant policies, and it's not just the homeowners or business owners policy. You want to get copies of the client's excess liability policies, their personal policies, personal lines, personal liability policies, any flood policies, because there may be a potential for flood loss as a result of these fires, and any other types of indemnity policies that might be triggered. So identifying coverage is the first step. Reviewing the policy, giving timely notice to the insurer. There's a lot of litigation on this, believe it or not, even though it seems simple. If you give notice to a broker, it's typically deemed notice to the insurer. But I always make sure that I give email notice per whatever the insurance company's webpage says. But the key is to get the written acknowledgement back from the carrier. And not only that, but make sure you give timely notice under all the applicable policies, including, look at policy periods and look at the types of coverage, which I've discussed before, both property and liability. Documenting losses, we're going to be talking a little bit more about that, but Alyssa touched on that. Insofar as submitting, signing releases, most policies do provide the insured sign a proof of loss. And if a proof of loss is tendered, experienced practitioners know you don't have to sign the proof of loss. But what you try to do is avoid filing a hostile proof of loss if you can avoid it. Try to prepare maybe a partial proof of loss or modify the language and get the adjuster to agree on it. And oftentimes they will. And that gets you the payment of the undisputed amount. So I focus in on trying to submit a proof of loss and reach some agreement with the adjuster at that point in order to collect. The other key obligations of the insured is cooperation, and cooperation makes sense in the sense that you're trying to get as much money as possible, and by resisting providing required documentation, you're just going to create a problem. And potentially trigger what's called an examination under oath, which is a deposition in essence that the insurer can compel of the insured. And you typically, that doesn't happen unless the insurer thinks that they're being taken advantage of. And then lastly, you have an obligation to preserve and salvage and subrogation rights. Now, this means, in some essence, keep in mind why you have to be aware of all the different policies and coverages available to your insured. You don't want to necessarily give a release to anybody that might prejudice your rights under your insurance policies. That's just, a quick summary practice tips.
Ed, can I
This is
ask
a
you a
re-
question about
Sure.
the proof of loss? So do you, if you file I think you said a partial for undisputed, and then how does that work going forward? Do you amend it as
Yes.
information unfolds?
Yes, so especially in business losses, there's payments you're going to get and at an interim basis. So you want to try to use that partial proof of loss or modified proof of loss to get a payment of the undisputed amount, so you can continue on to collect on the additional amounts. So and we can talk more about this, but there's real implications to obtaining early payment, even though it starts triggering time requirements, et cetera, et cetera. But getting that partial proof of loss, I found in dealing with insurance companies and sophisticated adjusters, they welcome a partial proof of loss. Why? Because the carrier requires them to try to obtain it. And rather than, like I said, file a hostile proof of loss that's going to get rejected, try to get the adjuster to agree upon a form of proof of loss in order to facilitate that proper payment. And you can include reservation of rights, I often do. And you can also include, this will toll the time for which I can reconstruct, et cetera, et cetera. Try to negotiate those provisions and get them put into that mutually agreed upon proof of loss. And I think that's a valuable tool in the claims resolution process. And so that's that slide. I want to just run through this. This was Alyssa referred to the fact we have equitable tolling, which means that understanding that suit limitation provision, this triggers a lot of malpractice. Attorneys aren't aware of the internal limitation provisions and policies. They'll think I've got 4 years for breach of contract. Not so. The internal limitation provisions in a policy is enforceable under Supreme Court decisions based upon the fact that there's a standard fire insurance policy in the state that has that 1-year provision. California has modified that strict 1-year limitation by allowing equitable tolling, and this is the case if you need it, and it basically says that from the date they start investigating the claim all the way to the point where they deny the claim or close their file, there's tolling of that 1-year limitation period. There's additional cases insofar as estoppel that's not been well received by the courts, but the courts will allow they will allow a type of estoppel if there's an affirmative misrepresentation by the insurer, and that's under a Supreme Court case called VU. But Prudential and VU were the two big cases in this area. Now let's just talk about the duties of the insurer. And Alyssa's covered most of these. I want to drop down to this, the third bullet, and that's they have to give notice of that denial and closing their file, and that's in order to trigger that 1 year. And you'll see that commonly. If you get that letter, you've got to calendar that date, the last date to file suit. Also, on this issue of limitation periods, good practitioners should be aware of the following. If you're going to file a suit against a public entity, you got to timely file a government code claim. And that's 1 year, within 1 year of the occurrence of breach. So government code claim is essential if it's a public entity. The other areas I'd be careful of, keep in mind that fires are going to generate floods. They always generate landslides and mudslides, and there'll be thousands of those claims throughout the country over a period of time. The flood insurance is difficult to get. I could talk at length of that, but the key policy, which is the federal flood policy, has an extremely short period of time within which you can give notice and file a claim. I think it's a matter of months. So if you have coverage under a flood policy, you've got to know what those dates are and just move very, very quickly. The periods for filing a claim are very short, and the courts will cut you off in the knees if you miss that date. Now let's drop down to implied covenant of good faith and fair dealing. Most attorneys know what that's all about. As I say to law students, it's probably the only contract in California under which you can obtain punitive damages and attorney's fees under a case called Grant. But to get there, keep in mind that if you're involved in the adjustment of the claim, it's probably not appropriate for you to be involved in the bad faith suit. So for that reason, oftentimes practitioners who are dealing with the claims will carefully document the file, take all the measures needed to preserve the insurance claim for bad faith, but assign that to a trial lawyer who will handle the bad faith case, as you may be a witness. The last thing, the insurance code, just so there's no misconceptions, the insurance code 790 sets out the fair claims practices. That is not actionable in a private civil matter. However, those standards are potentially admissible to show bad faith and mishandling claims. Again, you can't bring a suit in California under that code section for violation of that code. That's my understanding. Let's see. I think that's it on my slide. So
Okay.
I'm going to turn it back over to you guys.
Okay, so I think I'm gonna send it back to you here in just a second. Let's talk about business interruption claims, which have been a major issue for commercial tenants and property owners. Ted, can you talk about what the key elements that are for policyholders that they need to prove in these cases, and how have insurers responded to the claims?
Yeah. So business interruption claims, they are complex. The insurers will want to review all the financial and other business records in order to determine the amount of loss. The key issues will often be the amount of the deductible. Sometimes that's time related. The indemnity period is also a hot topic. The trending of the business. Businesses are not static. Their profits go up and they go down, and the insurance company will want to determine, and the insured will want to know, hey, what's the trending? Maybe how much money would I have made during the period of indemnity? So trending is a hot issue. And then the last big area is extra expense. And those are the additional costs you incur aside from the loss of rental or loss of business income. You can get extra expense coverage to cover things such as reopening costs, employee costs, carrying costs. So extra expense is a big coverage, which is typically, it's not typically, but it's often optional coverage under a policy. So those are the hot button issues. Often business, because of the complexity, businesses will employ public adjusters and attorneys and forensic accountants. Public adjusters can be problematic. I know many, there are many good public adjusters. However, I would caution your clients from signing an agreement in which they're committing a percentage fee to a public adjuster that does not exclude the undisputed amount. In other words, if the claim, parcel of the claim is undisputed, the public adjuster should not be able to collect a fee on that undisputed amount. You want to limit them to the disputed amount of fee that they recover. If it has to go to litigation, then they don't get anything, and that needs to be clarified in agreement. So agreements with public adjusters is something you're going to see.
Can you tell us a little bit about what a public adjuster is for those of us that are a little bit lay people in insurance?
Yeah, so the insurance companies have their adjusters. A public adjuster is typically a licensed individual or at least registered with the National Association of Public Insurance Adjusters. And they are skilled in adjusting losses for insurers. They represent policyholders. And again, they often, almost always, want a percentage. And unsophisticated clients who sign those agreements typically give a percentage of their recovery to the public adjuster. And if it's, oftentimes it's 7% or more, 10, 15%, some become
10% usually.
10, 15, 20. I mean, they will take.
Yeah, that money goes directly to them too. Often once that contract is signed, the money goes directly from the insurance company to the public adjuster, because they've probably in their intake packet gotten a signature that that's where that money goes. So it gets deducted, and fully agree with that advice, Ted, that, undisputed amounts, especially when you're dealing with these wildfire catastrophes where there's total losses, there should be so much of that policy that is not disputed. So
yeah.
And
And while we're talking about public adjusters, we probably should talk about attorneys who take matters on a contingency fee. Oftentimes, you always must, as a practitioner, put the interests of your client ahead of yourself. Don't take a contingency fee on a recovery which you know you can resolve quite simply with, on an hourly fee basis. It's just improper. But you'll find unscrupulous attorneys, just like public adjusters, just like contractors, who will attempt to take advantage of unsophisticated homeowners, and that should be discouraged.
Yeah.
And I think that's it on public. I mean, I could talk for hours on business interruption, but if as an attorney you can get the loss resolved without litigation, just factor in, remind your clients to factor in those litigation costs in making that decision as to accepting a settlement offer from the insurance company. Good insurance companies will adjust these losses in good faith, evenly, in some cases lean over backwards to take care of the insured. And, business interruption claims, they are just complex because of the complexity of the businesses involved. And it's a great issue. I think it's going to generate of unending litigation over the next decade. So the public will need the assistance of good counsel in order to get these disputes resolved efficiently.
Right. Thank you, Ted. Could you explain the difference between residential cash value and replacement cost coverage and how these distinctions play out in fire-related claims?
Yes, I think according to a Supreme Court decision, the actual cash value means the fair market value of the property or the damage. Typically, actual cash value is determined by cost estimates of the repair or replacement less depreciation. Okay, that's a key factor. They're under actual cash value, they don't pay you for the value of a brand new home. They pay you for the value of your house that's been lived in and depreciated and has not been upgraded for a period of time. And it's an arguable issue as to what the actual cash value is. Replacement cost, on the other hand, is the cost that the insurance company pays if there's a full loss of the home. It's the amount the insurance company pays to replace that house. And in some cases, many cases, there is a code upgrade coverage. It's optional code upgrade coverage, but that will make sure that the homeowner can rebuild the house in the same place and meet current codes. So its replacement cost is typically a lot more than the actual cash value. Oftentimes 20% or more. When you add in code coverage, even more. So that's the difference between the two. Replacement cost is not reduced by depreciation. So there's more coverage. Recently I heard an explanation as to why replacement coverage came about. And there's a basic concept in insurance that the purpose of insurance is to make the insured whole. It's not so that the insured could profit. And so they want to make sure that, and the reason for that is if the insured could profit, and contrary to what you're reading at social media or on YouTube, no, the purpose of insurance is not so that you can profit, it's to be made whole. And the rationale there is it would create a moral risk that insureds would be less than diligent in protecting their property if they could profit and walk away with the value of an upgraded whole new home. That's not the purpose of the insurance. So what the insurance companies require is that you actually expend the funds on the repair or the replacement of the house. You can do it either rebuilding the house, or as Alyssa pointed out, you can buy a home somewhere else. But they mandate that you spend that money. And the purpose of that is to, as I said, to not only, it generates more premium for them and reduces losses, but it's also to avoid this moral risk.
Great, thank you. Okay, let's move on to last question in this category. I'm going to throw this to you again, Ted. From the plaintiff's perspective, what challenges have you seen homeowners and businesses face when filing claims, particularly with issues like bad faith denials or cancellations?
So, you know, typically, you don't, I'm not going to say bad faith is rare. A lot of times you find insurance company adjusters who are overly aggressive. They come out with these programs, Exactimate, and they create, you know, significantly lowball estimates for the replacement or repair of a home. But that typically gets resolved in the claims process. The insurance company management does not want bad faith lawsuits. So you don't see a lot of that. Cancellation is not the big problem today. The big problem today that homeowners insurers are facing is the inability to purchase insurance in the future, non-renewal. They try to resolve some of that through statute and regulations about the obligation to renew. But if you think of this as a, you know, 2 to 5 year process of rebuilding, how do you know you'll be able to obtain insurance at a reasonable rate once you finish that home? So the availability of insurance is going to have a huge impact on people's decisions as to whether, you know, financial decisions as whether to rebuild or not. Emotionally, a homeowner will rebuild in the same location. Why? Because they love their home, they love their neighborhood. But oftentimes you got to think about this. How am I going to pull millions of dollars out of my pocket or out of my account? Add it, you know, you're talking in the Palisades, homes are often worth 5, 10, $20 million and up. Are you going to pull millions of dollars in years out of your life to build some speculative property that, you know, you might live in or might not, only to find that you can't afford insurance for that property? And so that's a serious problem. I think we'll deal with it. I think society and in our community will learn to deal with that and build insurance backups. But right now, everyone's going to get, every homeowner, whether you sustain the loss or not, you're going to face a premium increase in order to take care of insurance fund, in order to take care of backup funds for utilities so they can pay the claims. But that's a big issue right now, is the ability to procure insurance at a reasonable rate in the future. More significant than bad faith by far.
Yeah, and that, like you said, that cost increase, I think, is going to hit everyone in the state. I'm feeling it myself. All right, let's move on to our next category of litigation and liability. Lissa, you've worked extensively with wildfire victims. What are the primary legal arguments being used against utilities in wildfire cases?
Let me get more slides up here. So, you know, once your claim has kind of gone through its adjustment period and, you know, again, this is from the victim's perspective, or if you're representing the victim, what I specifically do as the majority of my practice is I represent wildfire victims in third-party claims against utilities, typically when the wildfire is utility caused. And so I just want to walk through the types of claims that are made in those third-party cases. I'll just say at the outset that most people who have experienced a loss due to a wildfire are underinsured. That can be a number of reasons. Either their policy limitations weren't updated or kept current as time went on. Maybe they got a policy 10 years ago or more, and they didn't really talk to their agent, or their agent didn't come to them. They didn't up the policy limits. Prices have skyrocketed for construction in California, labor in California, not in the least due to the wildfires and the destruction that we've seen. And then when you have a mass disaster like the Eaton fire, for example, the Palisades fire, you're going to have surge pricing because of, you know, lack of resources, again, because of the need and the desire to have the building done. So people will be underinsured as a result of the circumstances, even if they weren't underinsured, you know, if it had just been a single home incident, right? So what do we do when we file these third-party claims? Obviously we could do a whole discussion about how the Eaton fire in particular was ignited. It's currently believed to have been ignited by Southern California Edison's transmission tower. But I'm just going to go through the claims, and one of the most important claims is inverse condemnation. That's different than what most of us, typically see in a lawsuit that we file for a civil lawsuit for liability for personal injury, right? Which is typically based on like negligence. Inverse condemnation is a legal action where the property owner sues a public entity in order to receive compensation for property damage, even where the government hasn't formally initiated an eminent domain proceeding. So this is kind of the flip side of eminent domain. It comes from the same place. It comes from the takings clause, which states that private property cannot be taken for public use without just compensation. But here, typically, when we're talking about a utility-caused wildfire, it's not a planned taking for some sort of public improvement. It is an accident, or negligence or some other activity, or it's the equipment or facilities of the utility that have caused the damage or the harm. Unlike eminent domain, where the government initiates that taking, here we have a lawsuit filed because of the impact to the property that in fact decreases the value or completely destroys it. This is a very powerful claim for fire victims in California. Utility companies like PG&E, Southern California Edison, SDG&E, I mean, these are essentially hold monopolies over this. And so they have been held to be akin to a government entity, and so therefore subject to inverse condemnation. They continue to take opportunities to argue that, but argue that in the Court of Appeals and taking it up the ladder, but they have consistently been held to have inverse apply to them. And why do they not want it to apply to them? Because it's akin to strict liability. So with inverse condemnation, not negligence, obviously you've got to prove causation. You've got to prove that they were unreasonable in their maintenance or their what they were doing, right? Duty breach, cause, you've got to prove all those things. But with inverse condemnation, you only have to prove that their equipment was responsible for starting the fire, that it ignited it. So it's a lesser standard there, and it also allows victims to recover additional things that aren't available in negligence, attorney's fees being one of the big ones. And so it's a powerful tool when you're seeking damages against these companies. We also include other causes of action. Negligence is one. Negligence is important and should be included because it permits and allows you to form a basis for punitive damages, which in these cases, we do file those and seek those damages because of this history of, fires, because of equipment being old. The investigations have revealed a basis to seek punitive damages. So obviously you have to have the negligence cause of action. There's other things as well that would be public nuisance, private nuisance, premises liability, trespass, and then violations of various codes that apply to these utility companies. Have I answered that question? I was going to talk a little bit about damages as well, because I think that's a really important component of what I do specifically, but for victims in third-party cases. Do you want me to go on to this?
Yeah, well, I think that's great.
Yeah. So, I mean, this is, I think, important to understand what victims can seek when they bring these causes of action. So the law in California for property loss in a civil claim is that you are entitled to the diminution in value or the cost of repair. Interestingly, whichever is less. And so for most people, it would be DIV would be less. So there is an exception that's been carved out in California. It's called the personal reason exception. And what that says is that if you have a personal reason and a genuine intent to rebuild your property, at the location where it was destroyed, you can get more than the diminution in value. So you can get the reasonable cost even if they exceed the diminution in value. This is another important tool, an important thing to be aware of if you're working in wildfire cases. And actually, you have to, those things have to be true. You do get people in the aftermath of a traumatic event like the Eaton fire who aren't sure what they want to do, who may want to move away, may want to rebuild. There's a lot of hiccups along the path to rebuilding, permitting, just, all kinds of like public services, whether it's, reestablishing gas or water, or, it just, things become a mess. And so it can be a long road to get there. And so it's important that people are actually establishing that they have a genuine intent to rebuild, not just trying to get the higher cost of rebuild as part of their lawsuit. And that is something that utility companies, they'll defend damages on that basis and say, we don't believe you have a genuine intent because you haven't done anything in the 4 years since your home burned down. You've not gotten permits, you've not gotten plans, etc. So this is something that does come up in the third-party cases. But the personal reason exception does allow for those greater costs to rebuild, and they are typically more. It turns out to be more in terms of the amount of damages that you can seek. You also, you also can obtain loss of use during the period of repair. And there are a lot of ways where the insurance side of this intersects with what we do in the third party case against the utility. This is one of those areas. So loss of use sort of intersects with additional living expenses in the sense that, it can serve almost as an offset to the damages that you're seeking, right? But loss of use is basically meant to provide you with additional living expenses for the period of time that you're out of your property while it's being repaired. And so that can continue when you have these mass disasters for many years. In Thomas and Woolsey, we had people who 5 and 6 years later, their homes still hadn't been approved to be moved back into. It still hadn't been completed. And so if you compare that to the damages, or excuse me, the benefits that are available under most insurance policies for homeowners, their additional living expenses will go 2 years, sometimes extended beyond that, or to some sort of monetary limit. And so the loss of use allows victims to get that loss of use every month for the period that they're actually out of their home, right? And that is really the rental market value of their home for the period of time. And that can be substantial in areas like Los Angeles, the Palisades, Altadena, these different areas where the fires have affected it. One last market value personal property. There was a touch on actual cash value. I think it's important to consider that also in light of personal property losses. These are, as Ted said, you don't get a windfall, you get to be put back in the position that you had before the fire. This is particularly true with personal property. I personally do not think this is a fair thing when your things get completely destroyed in a fire, that you're just entitled under the civil law to get the market value. So I had a brand new mattress that I bought and I slept on it for 3 years. I was the only one who ever used it. And then I'm entitled to the diminished, basically if someone sold that to me on their front lawn is what I'm entitled to go and get. So you don't get replacement costs of your personal property. And so people are always shocked to hear that because they lost everything, it no longer exists. You do not get replacement costs. You get the market value, which is an actual cash or decreased value. There's depreciation taken. One thing to note is just that if you have high value goods, jewelry, art, things of that nature, you need to look into getting appraisals for those things, because that doesn't always apply to those types of things that have increased in value over time, or that are very rare. Those can be appraised, and their market value is typically substantially higher. Lastly, on damages, annoyance, inconvenience, and mental anguish. This comes into play with some of those causes of action that I talked about earlier. And people that are victims of this are entitled to those things. In my practice, we use video testimony, we document through photographs, and often come up with statements from our clients. In these cases that are usually done through some sort of a mass tort litigation, people aren't always deposed, and so you have to come up with a way to prove their annoyance, inconvenience, and mental anguish. So keeping track of what they experience, their displacement difficulties, financial difficulties, loss of treasured possessions and things that are irreplaceable, all of that goes into proving up their annoyance, inconvenience, and mental anguish. I think that's all for this section.
Okay.
So Peter,
Thank you.
thank you.
I think the time is going by so quickly. I think I'm going to move forward a little bit in our outline that we have to the regulatory and financial relief section to talk about FEMA just a little briefly. So wildfire victims often rely on FEMA assistance, but the process can be complicated. Lisa, can you tell us what claimants should know about navigating FEMA claims, and how does FEMA assistance interact with insurance coverage?
This is a pretty short answer for our timing here. So FEMA is intended to meet the basic needs of a household for uninsured or underinsured losses, necessary expenses, and it's designed to sort of jumpstart recovery. So the important thing to know is that if a homeowner has insurance, they must file their claim with the insurance company first. And it goes in how much they're going to get, how much they're underinsured. That goes to FEMA's decision about how much they might get from FEMA. By law, FEMA cannot duplicate benefits that are covered by insurance. So, in the case where you have a total loss, like we're talking about with many Eaton fire victims, the homeowner is eligible if they don't have enough. But other folks who maybe just were affected by the fire but didn't have a total loss, they've got to look to their insurance first before they can seek those FEMA help from FEMA. There are a ton, I won't go into them, but there are definitely deadlines associated with FEMA applications and things that you have to fill out. But it is a resource, as well as SBA loans that victims can turn to if they, in the meantime. I mean, one thing I'll say about third-party cases is that it can take a long time. You've got a mass tort, you've got a utility that is typically well-funded, and they can fight for a couple of years before there's some sort of resolution protocol in place. And so people need resources more urgently if they're underinsured. And so FEMA and SBA, there's other resources as well out there, but people do need those in order to get moving. But gotta go through your insurance first.
As I recall from when we spoke on our prep call, there's other things that don't offset FEMA, correct? Like if you're getting money from a utility company, does that gonna offset what you can get from FEMA or from insurance?
So the only thing, in my experience with a third-party claim, the only thing that serves as an offset in terms of what the in what the utility company can deduct from the total losses is what was paid out by the insurance. So, they can ask those questions or make that argument, but typically, at least in my experience, we don't even really consider it. It's a third party or collateral source that we don't bring in. The insurance subrogation will file their own claims against the utility company, and those claims will be dealt with through subrogation's attorneys and will be settled independently of the individual plaintiff's cases. And so Edison will know exactly what was paid out, in other words, through the subrogation connection and those cases, and then that serves as a deduction from the total losses claimed. Hope that made sense there.
Yeah. Okay. Great. Thanks. Okay, well, I think we should probably wrap up our structured discussion and turn to some of the questions for the panelists. So let me just, there's a number of questions. I don't think we're going to get through all of them. So, okay, all of these are from anonymous attendees. So here's one: is a formal claim similar to a Tort Claims Act against SCE a condition precedent to filing suit against SCE concerning the Eaton fire?
No,
Simple and sweet answer. Excellent.
it is a private, yes, you do not need to do that as if you were suing the county, the city. It is not the same. You don't need to do that.
Okay, great. Here's the next question. If you rebuild someplace else, do you get replacement cost if your policy is replacement, not actual cash value? And what is included in that, such as code upgrades, etc.? Ted,
Well,
this might be
you want me
your
to,
report.
So yes, you're allowed to rebuild somewhere else, and replacement cost is in addition to the actual cash value. They're obligated to pay the actual cash value. The replacement cost is an additional coverage. In the old days, there were guaranteed replacement costs. Those policies are hard to find. Let me add something in this area. Many times these disputes where the insured either can't or is going to take a long time to rebuild, oftentimes we resolve these disputes by a cash settlement where the insurance company agrees to pay more than the actual cash value. The insured agrees to take less than maybe the full replacement cost limits, but gets an immediate cash payment in exchange for settlement. That's a very important tool to getting these disputes resolved. Oftentimes that might require a professional mediator, as insurance companies are wary of bad faith claims, and settlement offers are typically settlement offers by insurance companies are admissible in bad faith claims unless there's what we call a light waiver. So if you can get if you're at a loggerheads, you can go to a mediator. And I'm told, I haven't seen it, but I'm told that many of the ADR organizations are offering mediations pro bono and will waive administrative costs. So if you are at that point where you're at loggerheads, your client, for whatever reason, doesn't have sufficient funds or whatever, cannot rebuild or buy at another location, consider a settlement via mediation based upon a cash basis, cash payout.
Okay. Well, I think we're at our time. It's 1 o'clock. I want to thank our panelists, Ted Sennett and Lissa Roberts, for sharing their insights today. And thanks all of the attendees for joining the CLE session. If you have follow-up questions or need additional resources, feel free to reach out to LACBA or our panelists directly. And I hope everybody has a great afternoon. Thanks, everyone.
Thank you.
Thank you, Peter.
Thanks.
Thank you, Lisa.
Thanks, Ted. Bye.